Hello friends, Namaskar. In today's class, we will discuss section 480 of BNSS. The topic is quite important because whenever we are going to apply for the bail, specifically in the non-bailable offence, we have to rely on section 480 of BNSS. So we could say that as far as general idea is concerned, the said section deals with the circumstances under which the bail may be granted in non-bailable offences. It outlines the condition under which the person arrested or detained for non-bailable offences can be released on bail. Apart from that, it also specifies the situations where the bail may be denied. So we have to understand section 480 of BNSS not only in theoretical perspective but also in practical perspectives as well. I request all of you to maintain a proper notebook and please note down the valuable points. As far as subsection 1 is concerned, it says that where any person accused of or suspected of commission of non-bailable offence, in case he is arrested or detained by the officer in charge of a police station without warrant, or he appears before the court, or he inter alia brought before the court, but court does not mean the High Court or Court of Session. In that scenario, he might be released on bail. So we could say that if the concerned person accused of or suspected of commission of non-bailable offence, in case he is arrested or detained without warrant by the officer in charge of a police station, or he appears or inter alia he is brought before the concerned court other than High Court or Court of Session, he may be released on bail. But apart from that, there are certain exceptions to the said protocol. That is inter alia grafted in clause 1 and clause 2. Clause 1 says that such person shall not be released on bail if there appear reasonable ground to believe that he is guilty of an offence punishable with death or imprisonment for life. Example, a murder case. Subclause number 2 says that such person shall not be released if such offence is a cognizable offence and he had been previously convicted of an offence punishable with death, imprisonment for life, or imprisonment for 7 years or more. That is the prime category. And another category is that he had been previously convicted on 2 or more than 2 occasions of cognizable offence punishable with imprisonment for 3 years or more but less than 7 years. Apart from that, we are having 4 proviso attached with clause number 2. First part says that provided that the court may direct the person referred in clause number 1 or clause number 2 to be released on bail if such person is child or woman or sick or infirm. Basically, these are the special categories to which the exception could not be applied absolutely. Another proviso says that provided further that the court may also direct a person referred in clause number 2 to be released on bail if it is satisfied that it is just and proper to do so. And for this, the special reasons are required to be recorded in writing. Provision number 3 says that provided also that mere fact that an accused person may be required for being identified by witness during investigation or for police custody beyond the first 15 days shall not be the sufficient ground for refusing the grant of bail. If otherwise, he is eligible to be released on bail. In that scenario, he is required to give an undertaking that he shall comply with the terms and conditions to be imposed by the Honorable Court. Provided that no person shall, if the offence alleged to have been committed by him punishable with death, imprisonment for life, or imprisonment for 7 years or more, be released on bail by the court under this subsection without giving an opportunity of being heard to the public prosecutor. So basically, the said proviso is concerned with the process. So by the bare perusal of subsection 1, it is quite clear that if the person is arrested in connection with non-bailable offence, he is required to be released on bail immediately. But clause number 1 and 2 inter alia provide the exception. In case the offence is punishable with death or life imprisonment, the bail is not permissible. And apart from that, if the offence is cognizable offence and he has been previously convicted of an offence punishable with death, imprisonment for life, imprisonment for 7 years or more, he will not be released on bail. Apart from that, he is previously convicted for 2 or more than 2 times of cognizable offence punishable with imprisonment for 3 years or more but less than 7 years, he will not be released on bail. But the said exception is not applicable absolutely in case the person is child or woman or sick or infirm, and apart from that, the court may release the accused on bail if it thinks just and proper to do so. But for that, the special reasons are required to be recorded in writing, and apart from that, if the person is eligible for bail, in that scenario, he could get the bail, merely on the ground that he is required for the purpose of identification by the witnesses during the investigation or for the police custody beyond the 15 days, it shall not be sufficient ground to refuse the bail application. And apart from that, the court is required to hear the public prosecutor if the alleged offence is punishable with death, imprisonment for life, or imprisonment for 7 years or more. Now we are coming on clause number 2. It says that if it appears to the officer or court at any stage of investigation, inquiry, or trial, as the case may be, there are not reasonable ground for believing that the accused has committed a non-bailable offence, but there are sufficient grounds for further inquiry into his guilt, the accused shall, subject to the provision of section 492 and pending such inquiry, be released on bail or at the discretion of such officer or court on execution by him a personal bond for his appearance as hereinafter provided. So basically, it appears to the concerned official or concerned court that the offence is not the non-bailable offence. In that scenario, he might be released on bail subject to certain conditions laid down in section 492 of BNSS and section 480 subclause 2 of BNSS. Subclause number 3 says that where a person accused or suspected of commission of offence, punishable with imprisonment which may be extended to 7 years or more, or of offence under chapter 6, please be noted, chapter number 7 or chapter number 17 of Bharatiya Nagarik Sanhita, or of abetment of or of conspiracy or attempt to commit any such offence, is released on bail under subsection 1, the court shall impose the following conditions: that the person shall attend the court in accordance with the conditions of bail bond executed as per the protocol. Number B, that such person shall not commit an offence similar to the offence for which he is charged. And subclause number C, he shall not directly or indirectly make any inducement, threat, or promise to any person equivalent with the facts of the case. And apart from that, he will not cause disappearance of the evidence, including tampering. And court may impose such conditions as think fit in interest of justice. And as far as clause number 4 is concerned, it says that an officer or court releasing any person on bail under subsection 1 or subsection 2 shall record in writing his or its reason or special reasons for doing so. Subclause number 5 says that any court which has released a person on bail under subsection 1 or under subsection 2 may, if thinks fit to do so, direct that such person be arrested or commit him to custody. Basically, it is concerned with cancellation of bail. As far as clause number 6 is concerned, if in any case triable by a magistrate, the trial of a person accused of a non-bailable offence is not concluded within a period of 60 days from the first date fixed for taking evidence, in such case, such person shall, if he is in custody during the whole of said period, be released on bail to the satisfaction of the concerned court. And apart from that, for the reasons to be recorded in writing, the magistrate may inter alia reject the bail application. But the reasons should be sound, the reasons should not be general. Apart from that, the reasoning should not be based on mere conjecture and surmises. As far as clause number 7 is concerned, if at any time after the conclusion of trial of a person accused of non-bailable offence and before judgment is delivered, the court is of opinion that there is sufficient ground for believing that accused is not guilty of any offence, he shall release the accused if he is in custody on execution by him of the personal bond for his appearance before the court to hear the judgment to be delivered. The said section corresponds to section 437 of CRPC. So in nutshell, we could say that section 480 of BNSS inter alia provides the protocol regarding the bail. So basically, it inter alia incorporates the categories when the bail is to be declined, when the bail is to be declined, and apart from that, it provides the special cases to consider the bail application, and apart from that, it laid down the procedure, the conditions to be imposed, and apart from that, the persons who are required to be heard while disposing the bail application. And as far as the remaining clauses are concerned, it is concerned with specific conditions that the concerned accused person will not tamper the evidences, will not cause the evidences to disappear, And apart from that, it internally incorporates the protocol regarding the statutory bail in case the trial is not concluded within a specific period. The accused deserves the bail, and apart from that, if the bail liberty is misused in that scenario, the bail might be cancelled. So basically, it is concerned with the bail in non-bailable offence. So whenever we have to move the bail application as per the protocol of section 480 of BNSS, we have to understand and we have to keep in our mind rule number 1, 2, 3, 4, 5, 6, 7. Otherwise, we would be in a panic and we would not be succeeded to have the effective bail application. So whenever you are going to draft, just incorporate all the points in light of subsections as I awaited you earlier, so that you could have effective draft and you could defend and contest the same effectively without any legal technical barriers, which is also sine qua non to stand your case before the court, and this will also help you to enlighten the court, and apart from that you could get the efficient remedy in favor of your client. See you in the next video. Till then, Jai Hind, Jai Bharat.